Good afternoon or good morning, perhaps, if you are joining us from BC or Alberta. My name is Sephton Leibbrandt, and I'm an associate at Samfiru Tumarkin LLP, and we are, of course, the employment lawyers. Thank you for joining me once again on our regular Q&A sessions here that we host, almost weekly at least, and quite frequently. So look forward to answering everybody's questions today about anything to do with employment law, whether it's a severance package, human rights concerns, medical leaves of absence, anything to do with employment law whatsoever. That's what we're here to assist with, and that's what I'll be doing today, of course, as I regularly do on our typical installment here, this 30-minute Q&A. So looking forward to some great questions as typical, and as I always see here in these sessions. To kind of get the ball rolling here while we wait for some messages to populate in the chat. Of course, today is Remembrance Day, and perhaps in certain provinces, BC, I think, for instance, those folks are getting the day off, which is fortunate for them. In Ontario, we're not so fortunate in that respect, but of course it is Remembrance Day, a very important day to remember and pay our respects to those who have fallen for the society that we enjoy today, a free and peaceful society that we presently enjoy. So to kind of get the ball rolling on that particular topic, folks potentially ask, sometimes I see it, and it's been in the news of late, whether my employer can terminate my employment because I am wearing a poppy at work. And you think it's a rather odd, question. Of course not. How could that be the case? We're paying our respects to those who have sacrificed their lives for ours. And so it's a rather interesting question, and believe it or not, of course, in Ontario, an employer cannot prevent you from wearing a poppy, specifically between November the 1st and November the 11th. You're allowed to wear a poppy in Ontario, and I believe the same is true for Saskatchewan and Manitoba, is my understanding. And of course, you're in Ontario as well. So, your employer cannot ban poppies in Ontario. You legally have the right to wear a poppy at work between those dates, if you so choose to do so. Other provinces, though, interestingly enough, even though, for instance, in BC, they apparently received the day off today for this. They, are a different, set of circumstances. There is no particular, right in BC, for instance, to wear a poppy at work, or in Alberta. So it's possible that an employer could actually, in those particular provinces, BC and Alberta namely, could in fact ban a poppy at work, even though it would be a little bit strange to see it done. But that's actually a legal possibility. So if you're in Ontario or Saskatchewan or Manitoba, you have the right, again, from November the 1st to the 11th, to wear a poppy and pay your respects at work. And the employer cannot penalize you for doing so. If it's otherwise the case, then of course it is, if you're in BC, Alberta, for instance, then it's something different. Unfortunately, there the employer potentially could ban poppies in those provinces. But it's really depends on the employer and what ultimately they elect to do in the circumstances. Again, except for potentially uniform reasons to have consistency, or safety reasons, there'll probably be a few reasons for any employer to ban wearing of a poppy. But just to be clear about it, if you're in one of those other provinces, BC, Alberta, for instance, or any other province that's not Manitoba, or Saskatchewan, or Ontario, where poppies are permitted, of course, and allowed, and then you need to, of course, follow your employer's poppy policy that they may have, or otherwise, failing to do so could be potentially some kind of warranting of disciplinary measures of some nature. So make sure, again, if you're not in Ontario, BC, not Ontario, Manitoba, or Saskatchewan, that of course you follow your employer's poppy policy in that respect. If you're in Ontario or the other two provinces that I recently mentioned there, then you of course have the legal right to do so. So I see some questions popping up here, which is fantastic. Again, I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers, and this is our regular 30-minute Q&A session. So thanks, everybody, for joining us this afternoon, and look forward to another great discussion. So it looks like we have a question. from Reddit. Jack asks, is the only way to get max severance that you would be entitled to wages, bonus, car allowance benefits is by going to court? What are the risks of holding out? So no, Jack, it's a great question. To obtain your legal entitlements, there's no need for you to go to court and to litigate, as it would be called, your matter. Ultimately, your legal entitlements can be determined, without any judge being involved. And typically, in the vast majority of cases, there will be some agreement, between your lawyer, for instance, and the lawyer for the employer about what a reasonable notice period is in the circumstances. Of course, in terms of getting to what that period, of course, is to begin with, you're looking at number one, the person's age. Number two, years of service. Those are the two critical factors. Somebody who's of course older, typically 60s plus, usually we'll see a greater severance package necessarily than somebody who's in their 40s, for instance, because age discrimination, of course, in employment is absolutely real. That's number one. Number two, years of service, obviously very important. Folks who've been employed for longer periods of time are typically understood to have a more difficult time of getting back into the job market, finding another comparable job. And so folks with those kinds of longer service periods are entitled to greater notice of termination in that respect. And then the final thing would of course be typically your position, the nature of your employment. Basically, are you a management employee, non-management employee? And if you're a manager, again, typically believe that there are fewer management level positions out there than, of course, non-management level positions. So again, tending towards a longer notice period there from an employer. So those are the three primary factors. There are, of course, some other kind of additional factors, being your rate of pay. And of course, number two would kind of be the availability, generally speaking, of comparable employment for somebody in your profession and with your skill set. Certain professions, for instance, have lots of jobs, out there that are available for them. You get terminated from one job, you get another job, a week, thereafter. That's sometimes happens, but for the most part, again, you don't need to go to court ultimately to get your maximum legal entitlements. Ultimately, the employer has a legal obligation to provide you with those, regardless. And if they fail to do so, then again, you would have to go to court. But then, of course, the employer would be spending your money and time on legal costs to require you to do that, which would ultimately to be their disbenefit, simply because they're spending money probably on a case in which they have no reasonable prospect of success. So they're wasting money on legal fees. They'll have to pay part of your legal fees if you are eventually required to go to court because they are being completely unreasonable. But in my experience, and the vast majority of my matters, at least, typically resolve on what's called a demand letter. So informal negotiation between myself and the company's legal counsel. And typically, if everybody's being reasonable, we can get to what an agreement on a fair severance package is in the circumstances that accurately reflects, again, your age, years of service, position, and rate of compensation, and things of that nature. So a great question, Jack. Litigation is only probably required in fewer cases than in the majority. Typically what I see, again, most of my matters resolve based on a demand letter myself outlining to the company's legal counsel the specific legal arguments in terms of why my client is entitled to substantially more in a severance package. And usually, in my experience, again, the first offer from the employer upon termination is usually not in any way their best offer by any means whatsoever. So it's certainly good if you've been terminated of late to reach out to us, or even perhaps complete our severance calculator, which you can do anonymously, and basically put in some basic information there, and we'll give you kind of a rough estimate of how much severance you may be entitled to from your employer. So you can see the kind of the link has popped up there just in the left-hand corner of your screen below. So certainly go there, have a look, and see perhaps how much may be owing to you in the circumstances. And then of course you can reach out to us at Samfiru Tumarkin, and we can have a further look at the adequacy, or typically the inadequacy or deficiency of your severance package. So thank you for that question, Jack. A very good one. Moving on here, I see a bunch of other questions have come up, which is fantastic. Looks like somebody from YouTube has asked, Bro from YouTube has asked, can my boss change my hours from 30-ish hours a week to 16 since things are slow? So the simple short answer to that is that, probably not. That's probably, too much of a significant change, to be, legally permissible. Basically, that's reducing your hours by almost half, which would probably necessarily mean that you're earning, about 50% less than what you would typically, earn from the company. Now, of course, you have the option here, basically, either, and this would depend again on your kind of your years of service, your age, your position, your rate of pay, how long you think it's going to take you to find another comparable job. But strictly speaking, of course, you can act upon that, basically that breach of contract, bro, in the circumstances. You can act upon that, claim a constructive dismissal. Sounds just kind of at the outset here that is probably a constructive dismissal in the circumstances. Or you can kind of see if the employer thinks it's going to be a temporary thing, you like this particular employer, you want to remain there for whatever reason. Obviously, you don't have to claim constructive dismissal. You can kind of, just write to the employer, say, look, I don't agree with, this reduction in my hours of work. I think, I reserve my right basically to claim a constructive dismissal, but we'll see if this is going to be only a very, very temporary thing. Perhaps we'll just see how this goes in the interim. But certainly, you're going to want to do, one of two things: either, write to your employer and put your position on the record so you have that to rely on, later, that you just didn't condone this. Number one. Number two, of course, again, if you've been there for quite a long time, maybe several years, and you're depending on your age and your rate of pay and things like that, and how long it's going to take you to find another job, that again, you may be able to use this to claim a constructive dismissal of your employment that you've been terminated in effect, and to get a severance package paid to you by this particular employer. So definitely reach out to us about this particular matter, so we get some further context on it, and you can get a better, more detailed assessment. You can see the links popped up there. Of course, you can also complete our severance calculator and get a general sense that if it's the case you've been constructively terminated here, how much potentially are you owed by your former employer. But I appreciate the question. If you have another follow-up question, happy to go and answer that. Another question popped up here as well. Looks like from YouTube again. Samantha has asked, my partner just got let go from their job in the tech sector, along with a number of colleagues. Does getting laid off as a large group change what they're entitled to or owed? So short answer is, Samantha, absolutely not. It's funny you raise this question, because this is the question that I was speaking about on my last installment last week. The fact is, terminations of employment and someone's severance package are unique and specific to the individual, meaning, what's the person's age, what's their years of service, what is their rate of pay, what is, the nature of their profession, and things like that. I know I've got lots of clients in the tech sector right now, especially in Canada, that IT is, suffering greatly. It's a pretty, poor job market typically for folks in that sector, unfortunately, right now. So, to answer your question very simply and plainly, contrary to potentially, being be able to pay less money because it's a large group, it actually may tend towards a longer notice period, because again, this is simply a symptom of the the greater economy here, and that tech market again in Canada is quite poor from what I've seen of late, and that those jobs are quite difficult to come by in the circumstances nowadays. And so again, that tends towards, again, a longer notice period for your partner in this particular circumstance. Certainly on this one, probably a good thing for you to do to start off by doing is have a look at our severance calculator there at the bottom of your screen. It'll pop up probably in a second. So you can use the Pocket Severance Calculator, go and plug in your partner's details there, and that will kind of give you a rough estimate of how much you may be owed in a severance package, or he or she may be owed in a severance package in the circumstances. That's one thing you can do. Of course, if it's a case, it sounds like they've been terminated, probably a good idea to have, someone assess their severance package and make sure it's adequate. I was previously mentioning, typically in my experience, the first offer from the employer is not usually their best offer by any means. So usually it's a good idea to have, a lawyer look at those things and see, is it actually the case that this is a fair and reasonable severance package? Because in, my experience, for the most part, the employer's initial offer upon termination is typically, substantially below, what you're actually legally entitled to at common law, because of course the employer wants a good deal. They want you to sign off on a release, probably go on your way, and the employer gets a great deal, and that's that. And the vast majority of employees, unfortunately, do never challenge their severance packages by any means whatsoever, and so the vast majority of the time, the employer, unfortunately, gets away with murder in most circumstances. So that's why we're here to try to kind of spread the word in that respect, and to have to encourage folks to get some legal insight on their severance packages before signing off. So definitely go to our website, employmentlawyer.ca. It'll pop up probably in your screen there in a moment. And certainly happy to have a look at your partner's severance package. Make sure it's adequate. We have folks standing by all the time to answer your questions in that respect. So certainly feel free to reach out to us there and get a greater and more detailed assessment of your partner's situation. So I appreciate the question. A bunch of other questions rolling in now, which is fantastic. Again, if you're just joining us this afternoon, if you're in Ontario like myself or BCL Alberta, thanks everybody again for joining us, and very, very happy to be here as always on these fantastic 30-minute Q&As. So jumping right along now, it looks like Sam from YouTube has asked, not a question, a comment, but I appreciate the comment, Sam. I'll jump on to the next. If you have a question, you can certainly ask it. In terms of the next question, it looks like Great Gate from YouTube has asked, my employer had me purchase a bunch of equipment for the business with my own money. Then they fired me shortly thereafter and are refusing to reimburse me. What can I do? So I mean, if you purchased equipment, it would of course sort of initially depend on what does your contract of employment say. I assume there was some understanding, obviously, between yourself and the employer, either in writing or a verbal contract that hey, I'm going to buy this for the business. You're going to obviously pay me back for. I'm not just doing this out of my own goodwill, basically, towards the company. So I assume there's some kind of contract of some nature here, and you again probably want to try to enforce that. It depends, of course, how much money is actually owed and how much is this equipment worth. Is it tens of thousands of dollars? That's particular type of matter. If it's less amounts of money, potentially maybe a small claims court situation. But I assume there's probably some understanding here that the employer was supposed to reimburse you for this. So it sounds like on this one, probably initially you want to probably have a lawyer, look at this and see what the circumstances are. Do you have, a good case for some kind of a contract between yourself and the employer that requires the employer to repay you for that? Number one. Number two, if that's the case, you do have, sufficient argument for a legal contract that binds both you and the employer in terms of paying for this equipment, then probably you'd start off by writing these folks a demand letter and outlining again the legal reasons why they're required to pay for the equipment. It seems to be relatively a straightforward matter depending on the facts of it. If they refuse to pay, then again it'd be litigation, depending on the amount of money, potentially in the small claims court. But that again would depend on what the lawyer ultimately thinks of the matter. So certainly you can feel free to reach out to us about that situation, James. You can see our link there, employmentlawyer.ca, in the screen there. So we have folks standing by, can certainly answer questions in that respect. But probably something you'd want to have your employer want to have looked at by a lawyer to make sure you have a legal basis, of course, to proceed against your employer and to recover the money you say you've spent, which is I'm sure the case on getting this equipment for the business. So appreciate that question, and for asking that. If you got a follow-up question, happy to go to that. Bunch of other questions are rolling in now, which is fantastic. Looks like James from YouTube has asked, my boss and I were friends, but now he always asks me to stay overtime and help out with stuff, but I don't get paid for it. I feel bad because we're friends now, and I don't know what to do. So yeah, that's a tricky circumstance. Obviously, in small employers, James, when it's a very kind of tight-knit, situation, that you feel kind of awkward about, hey, like I'm putting all this extra time in to do other things for the business, but nobody's paying me for it. I mean, I presume that number one, the job that you're in is not a management level position, managers are potentially, excluded from, entitlement to overtime, pay, number one. If you're, a non-management level employee, then you would be entitled to overtime pay in the circumstances, depending on whatever your hourly wage rate and things like that is. You know, number one, you look at the contract here. What is if you do have a contract of employment, number one, does it, say anything in particular about, what you're entitled to, with respect to overtime? Does your overtime need to be approved by somebody? Is it simply the case that if you work overtime, you're going to receive overtime in accordance with the Employment Standards Act? So basically any time above, 44, hours a week is when you get time and a half there. So you want to look at that to begin with. What does the employment contract say, if anything? And then, depending on what it says there, again, it sounds like it's a very tight-knit, employer. Obviously, you want to make sure you're getting paid for the time that you're working. That's only simply, fair. At the same time, you certainly wouldn't want to approach it in the sense of, I'm going to get my, lawyer to write to you. We're going to deal with this. You just want to kind of bring it up and, again, assume that you have a legal basis to pursue, overtime or to be, entitled to overtime. Again, that your contract, permits you to take overtime, that you're not in a management level position that may be exempt. In those circumstances, probably just reach out to this person, to their friend, say, hey, look, I'm working on these extra hours. Can we, do something here to make it so that, my compensation is a little bit more fair and reasonable? And of course, if this person's actually your friend, they should, offer, something, or try to, do something to try to help you out in the circumstances that, whatever it is, it's a little bit more fair than you just working, more hours and getting paid, nothing for it. So probably that's the best way to deal with it initially. Again, by first looking at your contract, see what that says. And then, number two, reach out to these folks. Most employers, in my experience, when you reach out to them directly, and you have a good relationship with them, most people appreciate that. Most people don't kind of appreciate being taken off guard, basically. If they're being completely unreasonable and you're being forced to work all this overtime without compensation, that's a different situation. You can certainly reach out to a lawyer about that. The Ministry of Labor would be kind of your second recourse there, to enforce your overtime, payments and things like that. Those are probably the two kind of, again, last resort options you have, Ministry of Labor or, an employment lawyer like ourselves in the circumstances. So appreciate the question, James, and the useful one, no question about it. Excuse the pun. So moving right along here while we have a little bit of time left, looks like Hash Brown from YouTube, great name, has asked, new staff member has been harassing me. I made a complaint and my employer's response is to move me to shift time that I can't do. I've been here for 23 years. This is seniority account for nothing. So that potentially sounds like a constructive dismissal situation in the circumstances. I mean, if you've been regularly working a certain shift, and the only way to deal with this harassment situation is to move you to another shift, I mean, it sounds like there's probably something else the employer could potentially do other than just, move you to another shift. Again, if you've been working there for 23 years and it's the same shift time, and you can't work this other shift probably for your personal or family reasons, I would say you probably have a fair, decent argument towards constructive termination of your employment there, Hash Brown, and to reach out to us in that respect and get a further insight and more thorough review of it, especially after 23 years of service, because that doesn't seem to be fair or reasonable in the circumstances by any means. So you see the link that's popped up there below. Certainly feel free to reach out to us there. We have folks standing by to answer your questions in that respect and get you some more particular and thorough legal advice about your situation. But yeah, on the first glance here, based on what you're telling me, it sounds like potentially, again, this is a constructive dismissal situation, and the payment of a severance package owed potentially as a result. Again, you've been there for 23 years. It's going to be very hard pressed for the employer to prove that it's reasonable for you to have to move shifts because somebody else was harassing you. This seems completely nonsensical to me. So definitely reach out to us there. Happy to have a further look at your situation and circumstances, but I appreciate the question. Moving again along here while we have a few minutes left. Looks like Jihan from YouTube again has asked, my company is closing due to tariffs and says it has no money to pay owed vacation pay and severance. Man says if we sue, the company will just declare bankruptcy before a judgment. Okay. Well, that's certainly one way to respond. I mean, in the circumstances, obviously, if the company actually does go bankrupt, then in terms of pursuing them for a severance package, going to be extraordinarily difficult, basically impossible at that point. Of course, before the company declares bankruptcy, then that's a completely different set of circumstances. Until they can declare bankruptcy, they're still on the hook for your severance package and your entitlements. They're legally. It sounds like this particular employer is just trying to be very difficult, in the circumstances. In terms of vacation pay and severance, I mean, under the ESA, you're entitled to kind of some bare minimums if the employer does declare bankruptcy. Potentially, maybe $2,000, I think, is what is owed under the ESA if there's a bankruptcy. Otherwise, again, in a bankruptcy situation, and you can commence a lawsuit against the employer, again, the employer's still on the hook. They still have to pay. So, this thing about, it sounds like to me this is just an intimidation tactic and to try to kind of scare you off in the circumstances and to avoid, potential litigation. So, in those circumstances, I mean, the employer wants to do it that way. Well, it's to the ultimate, disbenefit because, instead of being reasonable and trying to negotiate, again, they may be incurring legal fees on a case where it sounds like they have no legal arguments, and so they're relying on this kind of threat basically to try to dissuade you from challenging your severance package, which sounds to be nothing in circumstances. So probably you should reach out to us about this particular situation. See, again, what are the extent of your legal entitlements. You can, of course, use your pocket severance calculator there to calculate, potentially how much your legal entitlements are, roughly speaking. And then, of course, have a further look at what the facts are of this matter and whether this makes sense to pursue the company here. If it's true that they have no money to pay. I mean, again, if it's actually true that they have no money to pay, the unfortunate reality is you can't get blood from a stone, right? That's the old saying there, and so that's just kind of the one issue that you need to kind of be thinking about in the back of your mind. Anything other than that, and this, just maybe simply just a threat, right? And the threat to kind of intimidate you to go away, and those kinds of things. Obviously, I don't take kindly towards, nor do anybody at my firm. And so, I think it's probably something you want to have a further bit of legal advice on potentially. If you're basically abandoning a severance package that may be extremely valuable to you, that may not make any sense in the circumstances, because again, until the company actually declares bankruptcy, you're still on the hook, legally speaking, for your severance package and vacation pay that you may be owed at the end of your employment there. So certainly feel free to reach out to us about that circumstance and situation, Jihan. So thank you for the question. Looks like we've gotten to basically all of the questions. I don't see any follow-ups here. So everybody, of course, thanks for the great session today and for all your questions. If you enjoy what we do here, then please like and subscribe and follow us here. Fantastic session as always and a pleasure. Again, I'm Sephton Leibbrandt, an associate at Samfiru, Tumarkin, LLP, and this was our 30-minute Q&A. I'm sure we'll be having another installment probably in the very near future. It'll probably pop up in a second. Looks like, yes, Thursday, November the 13th with my colleague, Haley. Definitely tune in for that. It'll be another great session here. But if you enjoy what we do, again, like, subscribe, follow us, and tune in for more Q&As and legal advice in that respect. So again, thanks very much, everybody, and have a great rest of your day here.